Good afternoon. My name is Doreen Hartwell, and I am an attorney in Las Vegas, Nevada.
Good afternoon. I'm Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals in Oregon.
Good afternoon, everyone. I'm Steve Jewett. I'm a Orange County judge or county judge in Orange County, Florida, and the Ninth Judicial Circuit in Orlando.
And would you like to introduce yourselves?
Good afternoon. We are Reno High School's Unit 5. My name is Ella Cantera, and I plan on attending University College London.
My name is Cole Boyden, and I will be attending Whitman College.
My name is Amelia Rosevere, and I will be attending Trinity College, Dublin.
And my name is Kevin Zhang. I plan to go to UCLA. Our unit coach is Mr. Scott Daniel, and our We the People teacher is Mr. Richard Clark.
Great, thank you. So the question that you'll be answering today is question 1. A result of the decision in Wisconsin versus Yoder is that, quote, any parent/guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious belief, end quote. Do you agree or disagree with this result, with the result of this decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
Saper ode, or dare to know, declared German philosopher Immanuel Kant in 1784, endorsing the acquisition of knowledge as essential to personal liberation. An ocean away, a young nation contemplated its own recent liberation. Like Kant, the founders considered education essential to an enlightened citizenry. Yet as Wisconsin v. Yoder illustrates, the contours of this fundamental interest remain the subject of a vigorous contest between the negative rights model, emphasizing private autonomy over one's own education, and a positive rights model, asserting an enumerated right for all to access public education.
Chief Justice Warrenberger, writing for the majority in Yoder, reaffirmed a negative right to education, carefully qualifying that religious claims for exemption from education should be addressed with great circumspection and attached to identifiable religious sects. The Amish Heritage Foundation overstates the result, claiming that any parent can refuse to let their child go to school or learn about a subject by saying it's against their religious beliefs. While we agree with the decision's logic, the ruling is a narrow, fact-specific religious exception to compulsory school attendance, not a sweeping right to invoke religion against a right to an education.
The right of established religious sects to withdraw from general public education requirements falls under the First Amendment, made applicable to the states under the 14th Amendment. 1925's Pierce v. Society of Sisters and subsequent rulings, including Yoder, established this negative right to education by allowing parents to direct their child's schooling.
In contrast, the Sixth Circuit's 2020 decision in Gary B. versus Snyder established a positive right to a basic minimum education where public schooling must provide a chance at foundational literacy. This decision, since vacated, endorses Justice Thurgood Marshall's dissent in San Antonio versus Rodriguez, a 1972 decision that ruled that the equal protection clauses of the 14th Amendment did not extend to parity in school district funding. The positive right to an education is further endorsed by 1981's Plyler versus Doe, which invoked the 14th Amendment to determine that children of undocumented immigrants had the fundamental privilege of an education.
The constitutions of individual states further protect the right to an education. Similar to the constitutions of 41 other states, Article 11, Section 2 of Nevada's Constitution declares, the legislature shall provide for a uniform system of common schools, established and maintained in each school district, echoing the federal Equal Protection Clause. Support for the right to education is further seen in the US's endorsement of the Universal Declaration of Human Rights, which in Article 26, echoing Kant's Enlightenment Edict, describes a right to an education that strengthens respect for fundamental freedom and tolerance.
To support freedom and tolerance, religious laws must pass strict scrutiny when courts are asked to intervene to protect individual expression, yet also protect access to education. For example, 1971's Lemon versus Kurtzman established a 3-pronged test under the Establishment Clause. The legislation must have a valid secular purpose, neither advance nor inhibit religion, and avoid excessive entanglement between church and state.
Although 1905's Jacobson v. Massachusetts prioritized mandatory vaccinations under the state's police powers, Employers throughout the COVID-19 pandemic have allowed religion to take precedence over mandatory coronavirus vaccinations, citing required accommodation of the free exercise of religious observances under Title VII of the Civil Rights Act of 1964.
By way of analogy, the parental right to religious freedom in education enjoys support in 1997 City of Bernie versus Flores, which in conjunction with the Religious Freedom Restoration Act prohibits the government from substantially burdening religion's free exercise unless it must do so to further a compelling government interest. Arguably, there is no more compelling interest than the literal and metaphorical health of our participatory democracy, a health that depends upon an educated citizenry, one that dares to know the value knowledge brings to liberty. Thank you.
Thank you. So first follow-up question. In the context of constitutional law, federal constitutional law, what does separation of church and state mean?
Separation of church and state could mean whether these people don't have a religious belief or claim to a god. One example is Torcaso v. Watkins, in which they ruled that praising to a god before being a town official was considered unconstitutional.
In relation to public education, which is provided by the government, religion may not be endorsed in an educational environment. Engel versus Vitale emphasizes this by showing that a school prayer at the beginning of elementary school, even though it was voluntary, was an establishment of religion because it was through public education.
How should a student's right to education? It sounds to me from what I heard from you that you guys all disagree with Yoder, that it sounded like you were professing that the importance of education would outweigh that, right? But maybe not, and I expect to hear that in this. How should a student's right to education be weighed against a parent's religious beliefs? And let's change the facts also in this. If in Yoder, the child that was being taken out of school wanted to go to school, throw those facts in, but also where do you weigh those? The right to education and then the parent's right to have religious beliefs and to impress those on their children.
So under Yoder, it was not the child that was at the stand, it was just the parents. And so the Supreme Court has not yet set a precedent for children who are making the argument that they would like to go to school. However, because Yoder is so narrow in that it only is supporting those with a firmly held religious belief, that we only have the precedent that the parent would overrule the child under the fundamental right to parentage. However, Justice William Douglas does bring up that child's right because he feels that in his dissent, he feels that parents are seeking to vindicate their child's own free exercise claims. And so he feels that's inappropriate.
Because there hasn't been explicit precedent set for the child's right to an education versus the parent's right to an education is the exact reason that we disagree with this decision so much in terms of the timeline of Wisconsin versus Yoder, in which the child was pulled out before high school, before they had the opportunity to engage in a civics course. The emphasis of a civics course really emphasized in Cook versus Raimondo, in which students explained that they have the constitutional privilege and obligation to receive the civics course, which is the reason why a child should have the right to direct their own education.
What are the advantages and disadvantages of having an established religion?
Could you emphasize more on that question, please?
Sure. So to the extent that, and you can look at this from a number of different perspectives, but to the extent that there is an established state religion, for instance, like the Church of England, that would be a country, had an established religion for the country. What would be the advantage of having such an established religion versus not? And then another way to look at it would be from the viewpoint of having a formally recognized religion, one amongst many, be it Christianity, Catholic, Protestant, versus not having a formally recognized religious group. What would be the advantages and disadvantages?
So this formerly recognized or explicitly established religion can become very deeply rooted in cultures of certain states, which can be dangerous, as we can see in the passing of blue laws in Connecticut and North Carolina, in which the Establishment Clause was directly violated by these laws. And for instance, the prohibition of alcohol sales on Sunday by establishing that as a day of worship.
One problem with established religion is that this could cause the suppression of other religions. One example is overseas within China, in which they target Muslims for just believing in Islam.
An example in France is the contrast between freedom of religion and freedom to religion. France has been having a lot of issues lately with hijabs, and it's been targeting certain religions. So in the United States, we have freedom of religion, which declares no establishment, which allows every single religion to flourish in its own states, whereas the freedom to religion gives access to only certain religions, not all religions.
I would argue that both a pro and a con would be having that national church involved in the lawmaking process. This could be a con because it could potentially help pass unjust laws that would, say, promote segregation or hatred from other religions, as my colleague pointed out. However, it could also be a pro because typically religions are moral and ethic, and so it could point out places where our legislation might be lacking in those morals.
How far does the right of parental control recognized in Wisconsin v. Yoder and Pierce v. Society of Sisters extend? So for example, if law enforcement wanted to take a warrantless DNA sample from a child suspected of a crime and the child said no, and the parents said yes, does the Constitution allow law enforcement to take the DNA from the kid?
If this is within an educational environment, you are under in loco parentis, which means you are under the power of the school. So especially if you are in athletics and do it in school, whether it's against what you say or not, since you are under in loco parentis, they are able to do drug testing and saliva samples as they so please against your will.
Another way we could see this is from the way of the medical viewpoint of whether or not we can gather this information on the students. We could draw a parallel to this as well with vaccinations, in which a parent could say no against a child's vaccination. However, this cannot happen due to Boone v. Bosman, which subordinates parental rights and the religious expression to a society's interest in keeping the spread of disease.
In states such as Idaho, who have religious exemptions for parents from certain crimes, it would definitely go towards the parent, because in Idaho, if you are a religious parent, you are exempt from child abuse accusations, or even as far as manslaughter. If you refuse to give your child medical attention, you're exempt from that if you can prove your religion. So in Idaho, it would definitely go to the parent.
What about, that happens to me every time.
Yeah.
I don't know how that works.
That's so
Just about to ask a question. All right.
Yes, the time went by very quickly. So Stephen, now if you would like to start with your feedback.
Okay. First of all, I just want to, your statement, I really like the structure of what your opening statement, because it started with the philosophy of law, with Kant and the positive and negative rights, and then it went into the, focused in on the decision in Yoder and how it was narrow, which I think is important. It tells me that you've read that case and not just read the cliff notes or the head notes. You actually read it and understand that what the court is saying is this case really turns more on the fact, or in my mind, completely on the fact that it's not, there's no real danger to society although I think they get that wrong, but they say that there isn't because these people, these kids are going to be farmers. They don't need this education. They're going to go into the old school Amish, and that's all they're going to do. The problem is, and I learned this from today, that it's only about 90%. Now that seems like a lot, but still there's 10% of the population that decides not to join that community. And if you're talking 2-3 million, that's a lot of people that are not going to be educated, not be prepared. So that's where I think the problem for Yoder is me. But you went into Yoder and you talked about how it was narrow, which is great. And then you opened the focus back up to general principles and other case law that deal with this area. So I think that was really fantastic, and really focused. You know, you start here, you kind of come in, and then you open it up, and then it's time for us to ask questions. So I thought that was really, really well done. You guys are clearly aware and have read this stuff, because our questions are not really, they're somewhat coming off some of the sheet, but we're sort of making them a little different. We're going down some rabbit holes that maybe you're not expecting, and they don't seem to be crossing you up at all. So really good job. Congratulations for making it to nationals, and good luck for the rest of the time.
Aaron?
I echo that. There was really a lot that I both enjoyed and learned from your presentation. And in particular, I liked some of your discussions on how, especially in response to the established religion question about what's going on in different countries and how that can be problematic. I really appreciated your knowledge about how different states are approaching these issues, and a recognition that there's a variety nationwide in terms of perception on, you know, should kids have more power in the system, or should parents have more power. You're very thoroughly versed on the case law and used it to answer the questions. On that last question, I'd say in Oregon, I'll tell you that it would go to the child in terms of under the state constitution. In Oregon, if a kid is being investigated for a crime in Oregon and the law enforcement wants DNA and the child doesn't want to hand it over without a warrant, the parent can't override that objection. Law enforcement has to get a warrant.
I thought you guys did a fabulous job. Your written remarks, just well done. You covered everything from the historical case laws, references to the Constitution. You gave you hit all of the major cases, but you gave specific factual, detailed information in support of your position. And I loved the theme of an informed citizens are required for, a democracy and government. And you stuck with that, and it came up again and again in terms of your responses to the questions. I like that you asked me to further clarify or give you some additional information with regards to what I was looking for with regards to the established religion question. And then I thought you guys nailed it. I thought you totally nailed it. Just great responses from everyone. Great examples, current events. It was just it was clear that you understood the constitutional principles, the precedents, and you were able to distinguish. And you pointed out repeatedly where there's not a precedent that specifically addresses the issue with regards to kids' rights to education, but this is your thoughts on it, and this is why. I just thought just really, really well done, and good luck as you continue on.
Thank you.
Thank you, judges. We appreciate it.
Great job, guys. Thank you. All right, we'd ask that you guys would go ahead and sign out. Have a good rest of the day.
Thank you, judges, so much.
Good job.
Bye. Good job.
All right, judges. Well, that is it for us for this first round. Would you like to go to the breakout room? Or, okay, I will do that and leave it open for a little bit.